Pranav Sayta, National Leader of International Tax and Transaction with us today. I'm also speaking with Dinesh Kanabar, CEO at Dhruva Advisors. Welcome to both of you and thank you so much for joining us. Let me start with you, Mr. Sayta, just to understand why is this a big deal? And should investors who are coming in through the FPI route and based in Mauritius, should they be worried?
So very quickly, this is an important announcement. The formal notification is expected. But this is important because for several years, Mauritius had really resisted introduction of the principal purpose test, which is through the multilateral instrument becoming applicable to the Mauritius-India Treaty. And what that essentially means is that any foreign investor who's invested into India through a Mauritius entity, in order to avail of the benefits of the Mauritius-India Treaty, the investor will now have to demonstrate that the principal purpose of investing into India through the Mauritius vehicle was not for the purposes of tax mitigation. And not only the principal purpose, but if one of the principal purposes is with that objective, then the treaty benefit could be denied. So that's the reason why it becomes important. This has been the case for some time through a multilateral instrument, but the Mauritius-India Treaty remained unamended. Now, with this particular amendment, it becomes important that they are able to demonstrate that one of the principal purposes was not to avail of the benefit of tax mitigation in India. The other is that there is some uncertainty in the language of when this becomes or when this would become effective from, and whether it would protect even grandfathered investments, meaning investments made before 31st March 2017. When it becomes effective, clarity and certainty on that front would be very welcome. And also the fact that it would not impact any grandfathered investments. For public markets, what is essentially important, especially for FPIs, is if there are holdings of shares in an Indian company pre-2017 March.
All right, we seem to have lost that feed at a very, very important point. I was waiting to hear the end of that sentence, but we'll get Pranav Sayta back and get that. What happens if you've got holdings before 2017? But let me come to Dinesh Kanabar for his opening comments. What we're trying to understand today and what our viewers would try to understand, that is this a negative impact for Mauritius-based FPIs, and to what extent will they be hit?
So two parts to it. First of all, India is a party to the OECD amendments, and one of the amendments is that every investment into using a treaty should, as Pranav was explaining, meet the principal purpose test, meaning thereby that if you are using the treaty of another country only for availing tax benefits, then the treaty should be denied to you. So if there is a US investor using a Mauritius treaty to invest into India, and the principal purpose of that is found to be only to avoid taxes which are legitimately avoidable under Mauritius-India Treaty, then the treaty benefits can be denied. Now, this principal purpose test is something which India has been renegotiating several treaties, and in several treaties it has been there. Mauritius is now going ahead and implementing. I think the real point is the point which Pranav mentioned in the passing, which is the applicability of the treaty. The wordings of the protocol which has been entered into to amend the treaty suggest that this amendment will apply to all existing investments and to all the past years. And that is not while that is not very happily worded, knowing how the tax office is likely to implement it is to go back and say that even if your investments were made way back in time, if the examination of that investment is coming up now, we will apply the principal purpose test. We will not grant you grandfathering, and therefore to that extent you are open and vulnerable to a tax payment in India. So to that extent, all FPIs could get very significantly impacted as a result of this amendment.
Sorry, Mr. Sayta, good morning, Neeraj here. Is that your assessment as well? Because, I mean, Mr. Kanabar seems to believe that it seems that it could be retrospectively applicable. I thought we moved on beyond that from an Indian landscape for a long time. Is that your assessment as well, Mr. Sayta?
That is right. That could be a possible interpretation. The protocol is not very happily worded. I would strongly feel that this was unintended, that they intended to make it applicable only prospectively. However, the language leaves much to be desired, and therefore I hope that some clarification to this effect is promptly issued, so that there is no uncertainty in the minds of investors. And I would feel that that's how, in any case, courts would interpret this particular protocol. But that's for the future. I think an immediate clarification would be very, very welcome and helpful.
Kanabar, pending that clarification coming in, how are clients likely to kind of react to this? Also, a word on that particular aspect, because a lot of estimates that informally we spoke to some fund managers, etc., and they mentioned that the quantum of FPI investments inbound through Mauritius route has come off quite significantly, not just because of GIFT, but even ahead of GIFT, and now because of GIFT even more.
I would agree with you. I think the use of Mauritius for investments into India has declined and has declined considerably. That said, there are two parts to it. First is this issue regarding retrospective amendment, which you raised earlier. And I think Pranav is being charitable when he says that it's just the language which could be interpreted. The way we see tax office actually interpret that is really something which is likely to be hugely negative. And to say that government is signing something today and which needs a clarification here and now itself would seem to suggest that maybe it's the intention of the government to really reopen past, and that's what it would appear to me to be. But what it therefore communicates, the question which you asked earlier, Neeraj, that we seem to have moved past retrospective amendments. Are we really reopening cases to go back and say that foreign investors again are seeing a bout of uncertainty? So to your question, while the Mauritius investments have reduced and reduced considerably, the question is, how does India look at its tax regime and what is the stability that we are given? And I would very much agree with Pranav that an urgent clarification to say that there is no retrospectivity intended is going to be very, very critical. Otherwise, we are sending out wrong signals.
Wow.
You know, just one point, Mr. Sayta, and you were mentioning that before you got cut off. I just want to go back to it, and maybe we need to reiterate, underline it, that what does this mean for investors who have been there before 2017? Because right now, people who are watching, investors who are watching, are going to try and glean what the immediate impact is. Hopefully, those clarifications will come. Ideally, if there's a treaty which is signed on March 7th, we shouldn't be waiting till April 11th to somehow find out. So, you know, how do you look at both those points?
So, in respect of investments made before March 2017, which are unsold yet, and which are yet to be exited from and gains to arise from, so far as such investments are concerned, I would feel that the level of such
Something with that answer. Whenever Mr. Sayta starts on it, his feed goes off. Do I have him back on? Can you hear me?
have him back on.
Can you hear me, sir?
Yes,
Yes, please.
Yes, very, very much.
Now it's a cliffhanger. We have to finish the story. Yes, please.
Sure. So sorry for that again. So I would feel that the grandfathered investments may not be too many or may not be significant, because most of them would have been exited to by 2024. But to whatever extent they still hold acquisitions made before 2017 March, there is again some uncertainty whether the grandfathering, which was guaranteed when the GAR provisions were introduced and when the treaty was originally amended in 2016, whether those would continue despite this principal purpose test being now introduced. And I would feel a clarification on that would be very welcome, because that would be otherwise a very real technical problem. Less for public markets, because not too many investments pre-17 may still continue to be held, but also more for private markets and private equity, etc. investments as well. Also, when it comes to investments in Indian markets, public markets, investments in units, for example, of REITs, InvITs, etc., or investments by feeder funds in Mauritius into mutual funds, which units were not even post-2017 acquisitions continue to qualify for the benefit of the treaty. Those also could be impacted by this particular protocol which has been signed, because those continue to be exempt or non-taxable under the Indian law, read along with the treaty, so far as they are not shares. So far as non-shares is concerned, even investments made post 2017 continue to be non-taxable. But if this protocol were to be implemented, then one would need to demonstrate that one of the purposes was not to avail of the tax benefits in India. And that becomes a bigger burden for taxpayers to claim the benefit of non-taxability in India now.
Well, low burden of proof on the tax authorities before they deny treaty benefits, but a high burden on taxpayers to prove that the arrangement is kosher, is what somebody else mentioned this as well. Mr. Kanabar, simply put, if they, okay, so in a nutshell, if the authorities come out with the clarification, hypothetically, that this is not retrospective, is then the impact mitigated, or even then the impact is high?
No, so two parts to it. First is the clarification is in respect of what items. So if you are talking about clarification in respect of investments made up to the date of protocol, I don't see a challenge. If that is clarified, that all future investments are the only ones which are going to be taxed, then people will do their investment portfolio, will rejig whatever they need to, or plan for those taxes and move on with life. The clarification has to therefore be very categorical in terms of its ambit. The way the clarification reads or way the protocol reads today, it seems to suggest that any assessment year, even prior to the protocol, would be subjected to tax. So it's the way the clarification comes, which is going to be very critical. And if the clarification is categorical to say future investments, no past investments to be impacted, then there would be no significant impact. Then people would sort of, as I said, either calibrate the tax impact on their investments or would restructure themselves.
Okay, and Mr. Sayta, the same question to you. It could be your interpretation could be different, but if they give the clarification, is the impact largely mitigated? Assuming that they give the clarification that until the date of the protocol or until this revision has been done, it is not retrospectively applicable. Does that mitigate the impact completely?
So let me put it this way to make it very clear. I don't think I expect a clarification that all investments which are made up to the date of the protocol signing will not be impacted. What I do expect is that all sales, any capital gain accruing arising on a sale after the date of the protocol being signed and becoming effective are only impacted, and not any exits, any capital gains arising before the date of the protocol. So I don't expect that investments made only after the date of signing of the protocol will be impacted. Even investments made before the date of signing of the protocol will be impacted, so long as the exit or the capital gain event arises after the date of the signing of the protocol. That is the clarification that I expect will be made, and that I think is the intention. But since I heard Mr. Kanabar saying only impacts investments made after the date of signing of the protocol, to clarify, that's not what I meant. At least I don't anticipate that coming through. That's one. And if that happens, then I would, and second, I expect that if an investment was made before March 2017, then whenever the exit happens, it will always stay grandfathered. That is the second clarification that I would hope to receive. So that's where we are. And if both these are received, I think largely the impact would be minimal. It would then impact very few investments made before March 2017, which also would be then grandfathered. So it would really impact maybe units, etc., holders who are not holding shares, but who still have public market impact. That then would be very limited, I think, of this protocol.
Yeah, let's hope for those clarifications to come in, and also the question about why put out something in a way where you create so much confusion. There really is no need for this kind of a panic, but you know, we'll wait and watch for what kind of clarifications coming. Thank you so much, Mr. Sayta, Mr. Kanabar, for speaking with us today. I just want to pull up that data point once again of how much, and this is NSDL data, as of Feb 2024, how much quantum is actually coming into India. And Neeraj made the point that it's come off. It has come off, and in that order, if you see, Mauritius is actually second because it's higher than what's coming in from Singapore. So the second largest inflows in that sense, or second largest assets under custody are from Mauritius after the US, and there's a significant gap. Of course, US is the largest, but Mauritius is no mean number. So the order would actually be US, Mauritius, Singapore, Luxembourg, and then UK.